There's a co-defendant.
But I don't
We don't
think
need
the
the
attorney
co-defendant.
is here yet. for that.
Okay.
There was a motion to dismiss filed.
Are you ready on the motion to dismiss? Counsel, I'll hear you.
Thank you, Your Honor. So, Your Honor, my client is charged with 5 counts of kidnapping a minor by a relative pursuant to Mass General Laws 265, Section 26A. And at issue in this case, I would suggest, Judge, is the notice to my client. I would suggest that there are 3 elements that need to be established. One, that there is in fact a court order depriving her of her custody rights. 2, that she was notified of that order.
Well, let's break this down one at a time though. A court order. Was there a court order?
Yes.
Okay.
The only element is notice, Judge. So,
All right.
That I would suggest. So, there's information provided in the statement of facts, but that there was an order and that it's alleged that the order was violated. I'm not contesting those elements. The element that I'm contesting is the notice. And I submit that according to the Beal case, or Beals rather, that the defendant is required to have been given actual notice of the court order. In this case, in reviewing the statement of facts, it begins essentially by saying it was made known that the Department of Children and Families had notified Ruth on Wednesday, February 26, 2025, that DCF would be taking custody of her 5 children. That, I would submit, suggests future action. In fact, at the time that conversation occurred, there was no court order. In the statement of facts, there's additional facts that suggest that there was some conversation.
Can I just stop you here for just 1 second?
Yes.
It was also made known that the Department of Children and Families had notified Ruth on Wednesday, 2/26/25, that DCF would be taking custody of her 5 children. Had notified.
Yes, that's what I was, but that was before the court order. So, in other words.
When was the court order?
I believe it was the following day, but it's not stated in the statement of facts. Again, suggesting that there was some future action. There's no dispute, at least I don't think there's a dispute, and it's certainly not in the statement of facts. My client was never served with the court order that granted DCF custody.
I know, but keep in mind I'm limited to the statement of facts.
Right. That's why I'm pointing it out. There is no actual notice in the statement of facts at all. There's an indication that they told her that they would be taking custody of the children. And there's some indication that there was communication with the co-defendant, Mr. Rivera, via text message about the court order, about getting the court order. But there's no indication that there was any text message or communication to my client. There is no actual notice set forth in the statement of facts. In fact, there wasn't any actual notice, whether in the statement of facts or not, but there is no actual notice in there. So I think what the Commonwealth's going to say is, well, there's an inference that because she was in a relationship with Mr. Rivera and that DCF told her that they would be taking custody, that somehow that is sufficient notice. And I would suggest that even under the standard of probable cause, the very low standard that the court has to apply here, there was no actual notice. I would suggest that's akin to someone saying, I'm going to get a restraining order against you tomorrow. And then the person doesn't hear anything else and then contacts the person who told them that, and then they say, haha, you violated the restraining order, even though you have not been served with it. And essentially that's what I submit the statement of facts sets forth in this case, that we would be taking custody. DCF doesn't get to take custody without judicial oversight, without a court order. And so I think that the similarities to my scenario are apt because Obviously, in my hypothetical, we couldn't convict someone of violating a restraining order if they were just simply told that someone was going to get one against them. There is no actual notice, there is no actual service. And so based on that, Judge, even under the very low standard of probable cause, I would submit that that the statement of facts fails and the case should be dismissed on that basis.
Commonwealth.
Thank you, Your Honor. So Beals does not stand for the proposition that counsel just tried to make it stand for, that it requires actual notice of the custody order. Beals factually is easily distinguishable from the facts of this case. In Beals, what you had is, you had a husband and wife. The wife just up and left and took the kids with her to New York. 10 days later, the husband went to court and got an ex parte custody order, and then the mother was charged. In that case, the mother didn't know of the court proceedings, the mother didn't know of the decision of those court proceedings, and the mother had taken the children, who she had lawful custody of, prior to any of that ever being initiated or even thought of being initiated. The more apt case, and actually, and even in Beals, the court starts their analysis by drawing a distinction by saying that in that case, in Beals, there was no court proceedings or custody order that had been happening at that point.
But now let me ask you this question.
Sure.
When they say, we're going to take custody, do you think that that's actual notice?
So I have a case that, if may I approach?
Yes, and I'll print it if you just give me the site, because I'm gonna print Beals and I'm gonna
All
take
right, I
this
brought a
over.
copy.
All right,
for you.
then I'll take that.
This is the court's copy. I did provide a
Okay.
copy to counsel earlier this morning. And in this case, what you have is a set of facts that is very similar to the facts that we have here, in which the defendant was notified that there would be the hearing the next day to determine whether or not DCF could take custody of the children. The defendant knew about the date of that hearing, and the defendant took the children and left the state. And the court in that case says the defendant was aware that the proceedings were taking place, and it was the defendant's responsibility, based upon the knowledge of those proceedings, to see how they were carried out. And that's essentially what we have in this case here. And so I think that the court needs to read that case.
I am gonna read that case.
And in reading that case, I think that the court will find that the statement of facts is sufficient to establish probable cause for these crimes.
Can I respond to that just briefly?
Yes. Well, can I ask a couple of questions
Yeah,
though?
sure.
Did she have notice? Because it looks like that she was actually granted, that the juvenile court actually granted custody on that same day, February 26th.
I don't know if it was the 26th or 27th that the order for custody was given, but it was, I believe it was on the 26th that DCF with Fitchburg PD went to the home. And it was that day that she was notified, along with the co-defendant, that the proceedings would be taking place, that DCF would be seeking custody of the children. And that they could appear at that hearing to contest DCF if they wanted to. And instead they opted to take the children and flee to Texas. And so again, that's very similar factually to the decision in Williams.
You wanted to respond?
Yeah. Whether or not the juvenile court order was on the 26th or the 27th, the conversation that took place was before the hearing, because obviously if they had gone there on the 26th with the court order, they would have left with the children.
Right.
So that hearing took place afterwards. So again, implying future action. Unlike the case that counsel just provided you, no proceedings had started yet in this case. The other thing is, counsel is adding some things that are not in the statement of facts.
I know.
They're not.
But you know what, in fairness, that was in response to my question.
No, I understand.
Okay.
I just wanted to make the court aware that it does not say in the statement of facts that they were given a summons and told that there was going to be a hearing either later that day or the next day. It's not in the statement of facts. That is something that may be elsewhere in other reports, but it's not in the statement of facts. And obviously, you know, Your Honor, that you're limited to the statement of facts.
I mean, the statement of facts, just to respond to that, the statement of facts provides the conclusory statement that is based upon the information I just gave the court, which is in defendant's own affidavit under, let's see,
It's cited, it's close.
6E. The defendant was aware that DCF would take custody of the 5 children. A response worker from DCF, along with members of the Fitchburg Police Department, were present at the address when the response worker was attempting to serve the defendant and Mr. Rivera with the court summons for the care and protection order to take the children into DCF custody. So that is part of the statement of facts.
Right, but not that there was a summons that you were supposed to appear that day. There's no indication that contact was made in the statement of facts with Ruth at that time.
By way of moving on to defendant's affidavit, going to F, by way of text message, response worker had been instructed by co-defendant Rivera to leave the summons in the mailbox. This is when they were at the home trying to serve the summons on both defendants. Co-defendant sent a text message to the response worker saying, leave the summons in the mailbox. So they were aware of that summons. Now,
Well, the co-defendant was aware.
Well, in the affidavit says there's a history of domestic violence, but again, the clerk did not have that information, but I understand the point. I mean, it's neither here nor there. I do question the wisdom of sort of giving people a heads up that we will be coming to take your children at some point. Seems to me like you should wait till you have the order and then just take the children, but that's neither here nor there.
I'm not here to defend
No, I
the
know,
Department of
but-
Children and Families. I do not work for them. I do not represent them. I am not justifying any of their actions. I only come into this proceeding once the defendant is charged with a crime for violating a court order. Whether that court order was legitimate or could have been contested by defendants is not something I know or I even look at. It's just not part of this
I know.
proceeding.
I'll give you the last word, and then I'm gonna take it under advisement. Cause I need to write on this. This is,
I was,
okay.
I have no problem with that, Judge. My only request is that, DCF proceedings, at least with respect to my client, are moving along rather quickly, and it's my understanding that DCF, is in a position to return the children to my client when this case is resolved. So I certainly have.
I know, but I can't.
I know, I have no problem.
Okay.
I just wanted,
Okay.
but what I wanted to ask for, normally I would ask for a status date. I was going to ask for if we could please get a bench trial date. I had her execute a waiver. In the event that the motion is allowed, it would be a moot point. In the event that the motion is denied, I would like to keep the case moving and put the case on for a trial, and we had agreed upon if the court can do it on September 23rd.
Yeah.
Does that give you enough time to?
Yeah.
And I did have her execute a waiver if you want to do the waiver.
I do.
Okay, thank you.
Yep. That works for both of you, September 23rd?
It does, Your Honor.
Okay. Yep.
Ma'am, can you please raise your right hand? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
Okay, so ma'am, I am told that you want to waive your right to have a jury trial, is that right?
Yes, Your Honor.
And I know your lawyers talked to you about all these things, so I'm not trying to talk you into anything or out of anything, but do you understand that you have an absolute right to have a jury trial?
Yes, Your Honor.
Do you understand that a jury would consist of 6 members chosen at random from the community?
Yes, Your Honor.
Do you understand that you and your lawyer can help pick out who they are?
Yes, Your Honor.
And you understand that their verdict, whether it's guilty or not guilty, would have to be unanimous?
Yes, Your Honor.
Alright, so, ma'am, I wanna explain to you how a jury trial works. When you have a jury trial, the jury and the judge do 2 different things, and I wanna explain to you what that is. When you have a jury trial, the judge presides over the trial. The judge makes rulings of law during the course of the trial. The judge would instruct the jury on the law, and the judge would impose a sentence in the event of a conviction. What the jury does is they find the facts. They decide whether the government has proven its case against you beyond a reasonable doubt, and you are of course presumed to be innocent. Do you understand that? So when you waive your right to have a jury trial, the judge still presides over the trial. The judge still makes rulings of law during the course of the trial, and the judge would still impose a sentence in the event of a conviction. The difference would be is that the judge would find the facts. I or another judge would decide whether the government has proven its case against you beyond a reasonable doubt, and again, you're presumed to be innocent. Do you understand that?
Yes, Your Honor.
And you understand the difference between a jury and a jury waived trial?
I do.
In understanding the difference, do you still want to waive your right to have a jury trial and have this case decided by a judge?
Yes, Your Honor.
And has anybody forced you, threatened you, or promised you anything in return for your admission here today?
No.
Find a knowing, intelligent, and voluntary waiver, and I will accept it. All right, I'm gonna take the other matter under advisement. I will see you folks on the 23rd.
Thank you.
Thank you.